All right, Tara.
Okay. Thanks so much. And thanks to everybody for joining us today. It's great to be a part of this. And my name is Tara Stingley. I'm an employment lawyer with the law firm of Klein Williams Wright Johnson Oldfather in Omaha, Nebraska, and the chair of our firm's labor and employment law section. And today we're going to be talking about best employee management practices in a changing employment scene. And Tiffany, I may still need you to move forward the slides. It doesn't look like it's appearing on my end. Okay, thanks so much. So as part of my practice, I represent primarily employers with regard to labor and employment law issues, the defense of employment litigation claims, and as we're doing today, talking about EEO training, which I think is one of the most important things and the funnest things that I get to do as an employment lawyer. If you can jump to the next slide. So I want to set us back in a framework of where we were kind of at the end of 2019. There was a lot of anticipation coming into 2020, if we can remember that, and it seemed like it was going to be a great time. This was going to be our year. And a mere short 3 months later, it felt like things turned into a bit of a dumpster fire. And so when we are shifting in and dealing with a changing environment, as certainly employers in the healthcare industry know, it requires us as employers to be nimble and be flexible. Next slide. And that we learn that we need to adjust to things, that what we may have started out with regard to a plan for moving forward may change and it may need to adjust in terms of the ever-changing employment context that we're moving into. And that's really the lessons that we've learned from the last 3 years in dealing with the pandemic and recovering from it, and now dealing with a changed employment environment in terms of recruiting, retention, and managing employees. Next slide. So we continue to still deal with unprecedented challenges to the workplace. We are dealing still with supply chain delays and material shortages and labor shortages, most importantly. I saw a recent study today that was released that talked about half of the applicants who commit to and accept a job offer end up later revoking. And so we're still dealing with significant challenges in managing and dealing with a decreased amount of employee or applicant loyalty in the workplace and the impact that that has on your hiring and recruiting and retention practices. We've also been dealing with still a lot of political and social justice upheaval that spills over into the workplace. And as we're gearing up for yet another presidential election, we're going to continue to feel the impact of that and the inevitable political discussions and debates that occur within the workplace and at the office water cooler and everywhere in between. And retention of employees still continues to be a topic that and an obstacle that we as employers are dealing with in keeping the right employees and finding the right places for them to be. Next slide. So many of you have probably heard of the concept of the Great Resignation. And we know that from recent studies that the percentage of US workers who quit their job reached a 20-year high in November 2021. And there were many reasons for that. Desire for greater pay and benefits, feeling that they were disrespected or undervalued in their current position. Certainly a lot of childcare challenges where daycares and schools were closed or had limited capacity, and parents had less flexibility in terms of managing childcare expectations and balancing that with the work environment. And a feeling of lack of advancement opportunities where if employees felt that they were at a dead-end job or something that didn't allow for a lot of advancement, that they were looking for a new opportunity despite their feelings of loyalty to their current employer. Next slide. And so from this came this concept of quiet quitting. And the concept of quiet quitting really isn't actually about quitting at all. It's the idea that workers were not really going above and beyond at their work anymore, and were really just doing the bare minimum in performing their jobs. Think Homer Simpson, the safety coordinator at the nuclear power plant, sleeping on the job or thinking about sleeping on the job or thinking about eating on the job when he's supposed to be committed to the position that he's doing. And a Gallup survey in June of 2022 found that 50% of employees met the definition of quiet quitting, and 18% were actively disengaged. And I'll submit to you that this concept is not really new. Anyone who is probably on this call and has been involved in HR for some period of time knows that there is usually a subset of your population that is not perhaps as engaged as you might hope and is perhaps not going above and beyond in performing their work. But what's interesting to me is, what does this indicate? Why are employees not going above and beyond? Why are they less engaged perhaps than they were in the past? Next slide. So this brings us to the concept of the Great Revolution. And it's really a move from survival to reinvention. Next slide. Where employees are questioning the work that they perform and why they're doing it and what does it mean. And part of this, I think, has surfaced from surviving the pandemic and really feeling like, people are questioning what they're doing, where they're doing it, and what is the result of the work that they're doing. We're also seeing certainly an increase of employees banding together through unionization efforts or just working together to negotiate for the terms and conditions of employment for their better well-being. And this concept of employees more focused on the employee well-being, of working to live and not living to work. Employee well-being was certainly important long before COVID-19, long before the pandemic hit. But now, as a lot of employers know, it's a concept that's really front and center. And employees and customers and companies face the economic burden of employee sickness and stress, both in medical expenses, lost productivity, lost focus. And so remote work has given employees a greater understanding and concern for their own well-being and the well-being of their family members. And they want companies and their employers to act more humane, to have a greater purpose that speaks to that connection and support. Next slide. So all of this, again, reiterates the concept that employers in this context have to be more nimble, more fluid, less reactive, and the workplaces have to be more meaningful and valued and personal. The workers are not widgets. They never have been, and they certainly aren't now. And that employers can think about simplifying processes and bureaucracy in favor of flexibility and in favor of employee well-being. Employees really have to acknowledge where they are at this time, that employees are at a different place and a different time and may have different needs in the experience that they're seeking and what they're really looking for in a workplace. And so I think all of this is important in the concept of measuring employee performance. And if you can jump to the next slide, certainly what I see a lot as an employment lawyer that provides counseling services to clients on dealing with common HR issues. The goal is to hopefully avoid a situation where something is developing into a discrimination claim or a wrongful termination claim. And if we can deal with employee performance issues in a practical and positive way and get employees to a more productive position, that's a win-win for everyone involved. But I also see it on the back end of the employment relationship where if a claim has been made, then we're dealing with trying to defend the employer's decision in terms of why they made a certain decision, why they let an employee go, and what the ramifications of that were. And so to me, performance evaluations, both informal and formal evaluations, are really the first step in that employment relationship. When you have irregular evaluations where employees are not being evaluated on a regular or consistent basis, there's confusion on the employee end of when they'll be evaluated or what the performance metrics are or what their employers expect of them. And ambiguous evaluations pose a lot of the same problems, that employee evaluations have to be clear and specific in order to be helpful and productive. They got to focus on the objective criteria and less on the subjective evaluations of employees. And I think most importantly in this context, when you have inaccurate evaluations that are being prepared, an inaccurate evaluation is almost less helpful and frankly more harmful than not having an evaluation at all. Employers have to be able to provide specific information to employees to improve performance and avoid that fear of hurting employees' feelings during evaluations. Next slide. I think in this context that part of the challenge in performing accurate evaluations that are conducive to improving employee performance and putting employers in a strong defensive position if they have to defend a discrimination claim that may arise comes from the challenge of what we refer to as being Nebraska nice. which is a great thing to be recognized for as our state, but it also presents a challenge when you're an employer that is inevitably going to have to deal with employee problems. Not everybody's going to be a great employee. And how do we balance that mentality of Nebraska nice versus being a direct communicator regarding employee issues? So let's talk about a few common mistakes that we see in this area with regard to performance evaluations. As I said a moment ago, performance evaluations have to be accurate. If they're not going to be completed in an accurate manner that accurately represents the employee's performance, you're probably better off not doing the evaluation at all. If you argue there is a long record of poor performance, then that should be objectively supported by the performance evaluations. And this comes up in my practice a lot, and I'm going to assume that nobody on this conference has made this type of call to their lawyer, but I often get the call where it's a Friday afternoon at 3 o'clock, an employer is in a pinch and needs to let someone go, and the circumstances are a little bit dire. And we may be dealing with an employee who is in several protected classes that presents a risk in terms of what decision the employer is making with regard to this employee. And the employer may argue to me that there has been a long history of this employee being a bad performer, a bad employee, of violating company policy, of not meeting expectations. And then when we talk about, well, what's actually in the performance documentation? What's in the personnel file? What will we use as our evidence to support this decision? Sometimes there's not a lot there. And sometimes what is there is not entirely helpful, or it's not consistent with what I'm hearing from the employer at 3 o'clock on a Friday afternoon when it's crunch time and we need to make a hard decision about what to do with an employee. So if there really is a long history and a long record of poor performance, then have some evidence of that. Have objective evaluations documenting those performance issues. And the next thing I would comment on is be aware of evaluation inflation. Again, this concept of Nebraska nice. Not everyone in your workplace is a rock star, and not everyone is probably going to routinely exceed expectations on a consistent basis. And we're not doing anyone any favors if we focus only on the glowing performance reviews and not talk to them about things that they could do better or things where there are areas for improvement. And we're only setting employees up for a difficult problem conversation down the road if we're not upfront with them in terms of whether they're meeting our expectations. Next slide. So this document shows a very glowing performance review, and this is similar to what I received in a file long ago in defending an employment discrimination claim, where the employer argued that there was a long history of poor performance by an employee. But when push came to shove and we actually start looking at the documentation in the file, we see that it really only focuses on all of the positives, and it provides very little discussion or objective criteria to inform the employee about what they could do better. So here we see, a nice column of pluses at everything that this employee is meeting expectations the majority of the time, and the overall comments are another solid year. Keep up the hard work. Well, if that's not actually accurate, if that is not an accurate depiction of what this employee is doing, then we're not being accountable to, and we're not setting ourselves up for success in terms of documenting performance issues that may be happening. So this is an evaluation that could use some work. So all of this being said, these are not really new concepts, but how do they apply in the context of hybrid or remote work situations, which a lot of employers are still dealing with in managing their employees since the pandemic? Next slide. So I would say in this context, the same general rules apply. We still evaluate employees generally on objective criteria, but now more than ever, if you have any segment of your population that engages in remote or hybrid work, we have to be confident in our abilities, our processes, and the tools that we're using to assess employee performance when you're not always there to see it. And in any workplace environment, there are going to be some supervisors and managers who feel like they really need to see and observe and be physically present next to an employee to see how they're doing. And certainly in the healthcare context, there is going to be a significant percentage of your workforce that has to be physically present to do their jobs, to care for patients, and to provide that care and service. But you may also have a percentage that are still working remotely or in a hybrid situation. And again, the same issues apply. How do we determine whether an employee is working? How do we determine whether they're working well? And frankly, how do we tell how much they're working? And if you think about it, even with your remote and hybrid employees, you may still have the same challenges compared to somebody who is physically located in the workplace. You may have an employee who comes to the office and is there present at their desk from 8 to 5, but they may not be actually working. They may be on their phone, they may be shopping online, they may be at the water cooler or talking with other employees rather than doing their job. And so those challenges of monitoring employees' performance and seeing whether they're actually working, those are going to be present whether somebody's physically located in your workplace or working from home. Next slide. Clearly, the pandemic and the remote and hybrid work scenario has highlighted this paranoia about, are our employees being productive? And I've included a little clip from The Simpsons, which is something I grew up watching and is still popular in our house. But this concept that for the first week of work from home, employees were really popular. They had their gear set up, they were at the kitchen table, and they were working. But it later devolved into employees sitting on the couch and leaning over and hitting the computer with a cane to wiggle the mouse and to hit a few keys. And if you look at it, 87% of employees in recent studies say that they feel productive when they're working both remotely and in person. But only 12% of CEOs actually believe this to be true. So where's the disconnect in all of this? And is work from home still effective? Is it still conducive to a productive workplace? Next slide. There have been many studies over the productivity of working from home versus working in the office. And if you look hard enough, you'll find conflicting studies on both sides of the fence on this issue, where some studies have found that there has been an increase in productivity of employees working from home, where they avoid the commute, they avoid the time of kind of transitioning from home to work, and they can just kind of sit down and get started. But there have also been plenty of studies, if we look at the next slide, talking about the decrease in productivity, that employees are not really focused, they're not engaged, they're not collaborating with their teams as much as they used to if they were physically present in the workplace. And so from all of this, we take away that if remote or hybrid work is going to be maintained as a part of your work strategy with employees going forward, you have to have some keys to managing performance in those types of situations. So let's jump to the next slide. And in this context, wherever your employees are located, clear expectations are always important. Set clear expectations in terms of what the productivity standards are, when employees need to be available, the hours of work, and what meetings are required to be attended in person and video, and what you expect of them. And the more objective expectations are, the better they will be. You'll also want to train managers of remote workers. And frankly, you always want to train your managers of in-person employees too, that to be thinking about those objective criteria of what employees are expected to do. Again, you may have some managers who are much more comfortable working with employees who are physically located next to them, but that might not be the reality of your entire workforce. And so for remote workers in particular, you'll want to make sure that the productivity concerns are real, or that it could stem from a fear of our inability to manage, train, or motivate remote employees. So talk to your managers and provide them with training on how do they manage remote workers effectively. Are they checking in with their employees, and how are they doing that? Is it by phone? Is it by Zoom? Are they making that connection? Are they setting expectations on how often remote and hybrid workers should be in the office and how they check in with their managers? Or is there a risk and an increase in kind of gone and semi-forgotten of remote workers, which can certainly pose challenges on the other end of managing employees and making sure that they're advancing and eligible for advancement promotions. You'll also want to think about how you're measuring employees based on achievements and outcomes. Again, this goes back to, did we communicate clear expectations? And in this context, more than ever, it's important to hold employees accountable to the expectations that you have communicated. Think about tasks, and the timelines for those tasks and targets, and be able to measure employees against those. And sometimes it matters where a task and when a task is performed. Sometimes it doesn't. So be clear with employees on that. And think about whether hours at your desk or hours in your home office equate to productivity. Again, think about being able to meet your employees where they are. Some employees can be productive at home, some may not. And you can have frank and candid conversations with your employees about that, to be thinking about what work are they performing and how can I tell if they're actually being productive in terms of what I need from them and expect them to do. Now, certainly in this context, the concept of surveillance and tracking systems and mechanisms has become ever important to employers. And some employers try to think about whether they should use some form of technology to monitor and track employee productivity. But in this context, think about whether the technology really does that, or does it just track employee presence? And does that technology help you in managing your employee, or does it hurt employee engagement? And if you look online and a quick search on Amazon, you'll find all sorts of tools for managing and tracking and surveilling employees in terms of what they're doing. There's mouse movers, there's mouse jigglers, there's cameras, there's all sorts of things to be able to monitor whether your employees are actually working. And if you look at the next few slides, you'll see some really great product reviews and options that are out there for employees to be able to take whatever the employer has put in place in terms of managing and surveying performance and be able to kind of work around it, to stop screensavers from starting, to jiggle the mouse to make sure it looks like the employee is active online. And if you jump to the next slide and the one after this, the reviews on these items are kind of hilarious, particularly from a labor attorney's perspective. But the lengths that some employees will go to avoid doing work or to work around the employee monitoring devices show you that these monitoring devices are perhaps not always effective as employers may make them out to be. And so again, we come down to, what is this employee actually expected to be doing, and how do we measure that? So that brings me to my next point, documentation. And because I'm a litigator, I always think about how I'm doing something and what the evidence will be to support a decision that an employer has made. And the importance of documentation cannot be overstated. We communicate clearly expectations to employees through the documentation that we're creating. And it also helps employees in understanding what they need to do to improve upon and to keep their job. And if, again, as I said at the beginning of the presentation, if we can get employees to a place where they understand what we expect of them, and they're able to understand it and to take it and to capitalize on it and get to a productive, successful place, that's a win-win for everyone. And you don't have to spend time talking to your lawyer about, what do I do with this employee and how do I let them go? Documentation also helps us demonstrate what you as the employer have done to notify the employee of performance issues. And I can't tell you how many depositions I've been in where an employee, even where they have clearly received documentation of performance issues, even where they have clearly signed off on it, and even where the documentation was very clear in terms of saying, here's what you did wrong, and here's what we expect you to do better. Most employees don't like to admit that they had done something wrong. Most employees don't like to admit that they aren't meeting their employer's expectations. And that's certainly true in the context of a discrimination lawsuit. So the more evidence that you as the employer have to show that we have talked with the employee about what we expect, and we talked to the employee about what they were doing well, and most importantly, what needed to improve and the consequences of failing to improve, you're going to be able to put yourself in a far better defensible position to support a decision that you made and to set it aside from any type of alleged discriminatory or retaliatory reasons. And again, most importantly, documentation just helps us memorialize those key facts and evidence that we're dealing with. And I get asked a lot, like, well, what does great documentation look like? In an ideal scenario, what should be in the file? And when I think about proper documentation, I think about very simply, does this document before me, if we jump to the next slide, does it state the who, what, when, where, and how? And if you kind of apply those 5 benchmarks, it's, I think, really easy to put together a very straightforward piece of documentation that is clear and is helpful to you as the employer. And so we think about, often a common mistake is someone fails to identify who the author of the documentation was. And this seems like a no-brainer, particularly if you're the one who creates a document and it's on your desktop and you know when you created it. But if you're no longer available at the company, or if that document, the electronic copy, goes away and it's no longer clear who created this document and when it was used, you want that information to be on the face of the document. So it's very clear where it originated from, who the author was, and when it was presented. You'll also want to think about including the date of the incident, the date of the documentation, and the specific policy or expectation that was violated. A clear way to do this is to point to or refer to a policy in an employee manual or handbook to say that this is the policy at issue that was violated in this particular incident. And also be clear in terms of what the consequences of further violations or deficiencies are. Again, don't shy away from that reality under the umbrella of Nebraska Nice. If the consequence is, if you do this again, you're going to be terminated. It's better to be clear and direct with employees about those consequences rather than shying away from that reality. And then also attach and make sure you memorialize the relevant evidence that was at issue. If there were particular problematic emails that were being exchanged that were in violation of your policies, like a harassing email, well, then attach that communication to your documentation so that it's all included in one place, so that you're not trying to track it down or find it later after the fact. And ideally, this type of documentation, depending on its severity or its seriousness, would be acknowledged by the employee and witnessed by HR or another supervisor, so that it's very clear that the employee received it, they were on notice of it, and they had a chance to improve. So if we jump to the next slide, and again, bear with me because this is another Simpsons example, but this documentation is pretty similar to what I had received in a file from a client many years ago when we were dealing with a performance issue and a disciplinary matter. And so the extent of the note indicated something similar to, yesterday Homer was caught making nasty remarks to a lady in the break room. She tattled on him and got pretty hysterical. We yelled at Homer to knock it off, and that was the end of it. Now my question to you is this documentation effective? And if not, what could be fixed? So I'm guessing I'm getting a few nods of the heads that this documentation is not great and it could be fixed. And if we look at the next slide, I've kind of taken that note and expanded it into what could be a better use of documenting that serious issue in a way that will be helpful to all of the parties going forward. And so I've styled this as a memorandum to the file from Human Resources, and we've included the date and what it's regarding. And then we spelled out in greater detail exactly what happened, who were the witnesses to it, who overheard Homer making the statement, and what exactly he said. You know, I'm always surprised that sometimes when I see documentation that isn't clear on what actually happened, what was said. Don't be embarrassed by it. If it was bad enough for us to be taking disciplinary action against an employee for what happened, then put it in the note so it's very clear in terms of what we believe, what we've concluded happened, and why we're taking disciplinary action against that employee. And then I would elaborate on how the statement came to Human Resources' attention, what we did to investigate it, and whether Homer admitted making the statement at issue and how it was in violation of his policy, and what we did in terms of not yelling at Homer, but we counseled Homer to avoid engaging in similar conduct going forward and to avoid retaliating against any employees that were involved in the incident or the investigation, and that additional violations would result in disciplinary action up to and including termination. And Homer acknowledged this understanding. And then we probably also followed up with the other employees who were involved in this to make sure that they understood that we appreciated them bringing this issue to our attention, and that they should immediately report back to us any concerns about retaliation, and that the employees acknowledge this. What this memorandum does in comparison to the note in the file is avoiding those inflammatory terms. And if we kind of jump back to the prior slide, if I'm a plaintiff's lawyer I'm going to jump all over the type of comments and terms that are in this documentation to question how the employer viewed this incident, right? Think about the terms. This lady tattled on Homer and got pretty hysterical. Well, do we view those kinds of reporting issues as tattling, or do we view it as a legitimate way for employees to express concerns about misconduct in the workplace? What about nasty? Well, nasty can mean different things to different people. And again, avoid any confusion about what was said and just comment or explain what Homer was reported to have said to the employees. We also probably didn't yell at Homer. Again, we counseled him to avoid making that type of statement and to avoid those types of issues in the future. And so all of those, I think, are simple takeaways to take this incident that happened and be able to explain it in a very objective, straightforward, clear way to be able to document the incident. Okay, so if we can jump forward to the next slide. So in terms of proper documentation, just some takeaways. Document promptly and contemporaneously when issues are clear and fresh in your memory. Focus on objective things like job duties, what the policy says, what the performance categories and metrics are. Be factual, accurate, and concise, and avoid inflammatory terms. Avoid emotions. And where appropriate, include key documents as objective evidence and preserve that evidence so that it is there if and when you need it. And if any of this is giving you any heartburn, then reach out to a trusted partner in human resources or your legal department to make sure that you feel comfortable with what you're doing. You'll also want to avoid bad documentation. And so, again, I feel like I'm preaching to the choir and talking to anyone involved in human resources for any period of time, but think about what you're writing. Think before you send something. And think about how it will be perceived 6 months from now after this incident has resolved and the dust has settled. How will someone else, a third party, a judge or jury or a plaintiff's lawyer, how will they look at this piece of evidence and evaluate it in deciding how to proceed? And that's set forth on the next slide. So I know I have mentioned a few times the importance of memorializing evidence. And if we look at the next slide, this incident in a situation with Chipotle Mexican Grill really highlights the importance of memorializing evidence. So in 2015, Chipotle fired a woman by the name of Michelle Ortiz, who was a 14-year employee, claiming that she stole $636 from the company safe. And the employee denied the allegations and said, no, you actually fired me in retaliation for my prior workers' comp claim. And then she sued Chipotle for wrongful termination. When the employee was fired, she had received consistently positive performance reviews. And she was actually up for a promotion for a $100,000 salary. And Chipotle claimed that it had surveillance video of this employee taking the money out of the safe and then dramatically fanning herself with the bills and then looking over her shoulder to see if she was being caught or if anyone was watching her. But then it lost the video by taping over it. And Chipotle also claimed that it accidentally deleted text messages and notes about the reasons for firing this employee. And the case went to trial, and the jury didn't appreciate or didn't believe Chipotle's reasoning and the rationale for the termination and ruled in favor of Ortiz to the tune of $7 million. So prior to termination, this employee had made $72,000 per year. She was up for a big promotion, and Chipotle had offered her a mere $1,000 to settle the case. But after the jury came back with a pretty significant judgment, Chipotle ended up settling the case for an undisclosed amount, to no one's surprise. So again, if you're relying on evidence to make a termination decision, preserve that evidence. Make sure that it is memorialized and retained and locked down and safe so it is there if and when you need it. We have a few minutes left in our presentation, so let's jump quickly to addressing requests for leave and accommodation. And again, more than ever in this context, in these changing times, it's important to think about how we are responding to employees' accommodation and leave requests. And the biggest challenges that I see in this context in counseling employers are where an employee has failed to recognize a request for accommodation or a need for leave. Remember that employees don't always need to use the magic words of, FMLA or I need a disability accommodation. It may be as simple as an employee saying, I'm having a hard time doing my job because of this. And that may be enough to trigger that obligation to engage in the interactive process with your employee about what they're dealing with and whether there's any need to accommodate the employee through a reasonable accommodation or even a leave from work. We also see employers continue to struggle with failing to provide additional leave time as a reasonable accommodation. And this most often comes up in the context of where an employee who has been eligible for leave under the Federal Family and Medical Leave Act and has taken 12 weeks of leave, when that employee is not quite able to return to work. And remember that employers generally have a duty to think about whether there is an additional obligation to provide leave as an accommodation for a disability. And so be cognizant of that additional obligation and be able to think through that when you have an employee who isn't quite able to return to work after exhausting an FMLA absence. And we also see employers who still struggle to understand undue burden. Remember that you as the employer are usually going to have greater resources to be able to deal with an employee's request for an accommodation, including leave. It may provide a burden on your workplace to cover that staffing absence, to have some employees who are working a bit more overtime, or to kind of accept a greater workload when they're dealing with an employee who is not at work. But that obligation is always going to be a greater expectation on the employer than it is compared to an employee who is dealing with a disability and needs an accommodation. And so be very sensitive to that issue before you are inclined to dismiss an employee's request for an accommodation as an undue burden. So in responding to accommodation and leave requests, we want to listen to employees. We want to be alert to employees' requests for help, even if they're indirect. And if you're unsure how to respond and you're worried about saying the wrong thing, you can always state the following. Thank you for bringing this to my attention. I'm sorry to hear you're dealing with this. How can we help you? Those 5 little words can really set the tone for opening the door to what an employee thinks they need. And if you can easily give an accommodation, just do it, right? If it's something where an employee needs a different keyboard or a different mouse, that may be a really easy thing to do rather than fighting the employee on it. And always, always document what was requested and what was done, and that the employee didn't ask for anything else. This is a picture of my grandmother's dog, and his name is Earl. And Earl never looks happy. Earl always has this face, regardless of whether he gets to go on a walk or he's gotten a new treat or a new toy. And what I want you to take away from this slide is, if this is your face and your response to when an employee comes in and they're asking for help, or they're asking for an accommodation, or they're struggling with something, you don't want to have this reaction to employees, because the message that sends is, you're a problem and I don't want to deal with you. And that type of reaction can be just as problematic when we are sending a message to employees that we don't want to deal with them. We don't really want to accommodate them. We don't really want to help them. So rather than taking the approach of Earl, my grandmother's dog, how do we avoid that perception from employees? And so the next case that we've included on this slide talks about a recent case from the 7th Circuit Court of Appeals from 2022. And in this case, the plaintiff wanted to take some time off of work. And in talking with the employer's FMLA manager, the manager discouraged the employee from taking that leave and instead kind of strong-armed the plaintiff into retiring. And the employee filed suit and argued that that discouragement and the manager not trying to work with the employee on how do I take FMLA and how do I exercise those rights, that was actually an interference with the employee's FMLA obligations and FMLA rights. And the Court of Appeals agreed with the employee and said that there's enough evidence here that a jury needs to decide how this case should come out and whether the employer is liable for discouraging an employee from exercising rights under the FMLA. And so we don't want to be in that position in terms of being accused that we haven't tried to work with employees to exercise their job protected rights and to take job protected leave. The next case from the Eighth Circuit, which Nebraska is located in, occurred a few years ago in 2019 and dealt with a similar issue where an employee asked for a leave of absence because of a serious medical condition that they were dealing with. And the supervisor responded and said, read the employee handbook. And didn't respond to them, didn't follow up, didn't elevate the issue to HR. And in taking a look at the employee's disability discrimination claim, the Court of Appeals said, hey, you as the employer failed in your duty to engage in the interactive process. Because once an employee asks for that leave of absence, that triggers the interactive process where the employer then has an obligation to take some initiative and think about what is this issue and does this employee need a reasonable accommodation to be able to perform the essential functions of their job. So in responding to accommodation requests, what not to do? Well, do not ignore the request. Even if it's unreasonable, you still have to engage in that interactive process with the employee. You don't have to give them everything they're asking for, but you also can't ignore the request. Also, don't combine discussions or documentation on performance issues with accommodation or leaves of absence requests. Because if you can't cleanly focus on the performance issues, things start to become mucked up with the underlying request for accommodation or the medical issue, and suddenly we're being accused of discriminating against someone on the basis of a disability, as opposed to being able to clearly and cleanly focus on how they're actually doing their job. And of course, most importantly, don't retaliate against employees for requesting accommodations or taking legally protected leave. And this is a hard one because particularly when there are other employees involved who don't understand why an employee is not present, why they're taking leave, it can lead to resentment by employees who feel like they're doing all the work. They're carrying the burden of this employee who's not doing their job. And so being able to create an environment where employees have those rights and that they can take reasonable accommodations as needed, and we're not going to retaliate against employees or freeze them out for doing that. So very quickly, as we're wrapping up our presentation time, let's jump to employee discipline and discharge. I know you're all aware of the concept of at-will employment in Nebraska, and I get asked the question a lot of why do we really care about what I do as an employment lawyer when we have at-will employment? And just because you can terminate an employee for any lawful reason doesn't mean that you always should. And your workplace culture and your ability to defend against potential claims of discrimination, harassment, or retaliation will be aided by incorporating basic concepts of fairness into your disciplinary process. And by fairness, we mean give employees notice of the rules, give them an opportunity to correct the behavior depending on the circumstances. You may have some things that are immediately terminable offenses. And for those things, we're not going to give people a chance to fix it. But most things probably can be fixed if employees are given the chance. Treat employees like others and act respectfully in making employment decisions. And a real quick employee discipline checklist in thinking about before we take disciplinary action, have we followed our own discipline process? Are we doing what we told employees we would do at the outset of the employment relationship? Have we provided notice of the rules on which discipline was based? Like, should employees have known and understood that this was what would happen if they violated this rule? And have we adequately investigated the misconduct? Again, if you take sufficient time to look into a situation and make sure that you have a clear understanding of what happened, you will be in a better, more informed position to be able to make a decision as to what to do. And also think about applying the rule consistently as much as you feasibly can to all employees. And on this point, so the next slide is a picture of my twin boys at about 6 months of age. And despite being they were born on the same day, 2 minutes apart, but that's really where the similarities end. They're now 12 years old. And I like to think about them and thinking about, well, how do we apply consistent levels of evaluation to two different employees who are different people, perhaps engaging in slightly different conduct in different circumstances. And as we note on the next slide, consistency doesn't always mean identical, but you have to be able to articulate distinctions in terms of what occurred, what was the policy or the standard that was violated, have we given prior warnings, and what are the mitigating circumstances? And then do we think through how have we treated other similarly situated employees in similar situations? And thinking through all of that, can we defend our decision as to why we're engaging in a certain disciplinary conduct here, but perhaps taking a different approach elsewhere? So some quick takeaways as we wrap up our presentation hour. In terms of employee terminations, consider if you can and if it's feasible and safe to do so, of conducting employee terminations in a face-to-face meeting. Always have another witness present, whether it's another member of your HR team or management. And if the employees request a reason, provide the honest, actual reason for termination. Avoid a laundry list of problems, and there's no need to debate the decision, but don't put yourself in a position where you are providing one reason for why the employment relationship is ending at the time of the meeting, but potentially making a different decision down the road once you're defending that position. Be honest, accurate, and consistent throughout. And with that, that brings us to the top of our hour for our presentation. There is a few more, a little bit more information in the presentation slides, but hopefully the Nebraska Hospital Association will be sharing that file with you to peruse. And with that, I thank you so much for the opportunity to talk with you today, and please feel free to reach out with any questions. Thanks very much.
Thank you all, and we'll be sending the recording along with the slides. Thank you, Tara.
Thank you.
Okay, and I'll just get on it. Oh, there we go.